We are Group 4 and today we are going to tackle about the GR number 157833, the case of BPI as the petitioner versus Gregorio C. Rojas as the respondent.
We will stating the narration of facts. Gregorio C. Rojas, respondent, is a trader. Sometimes in March 1993, he delivers stock of vegetable oil to spouses Rodrigo and Marisa Kawili. As payment therefore, spouses Kawili issued a personal check in the amount of 348,805.50. However, when respondent tried to encash the check, it was dishonored by the drawee bank. Spouses Kawili then assured him that they would replace the bounced check with a cashier's check from the BPI. On March 31, 1993, responded and Rodrigo Kawili went to the petitioner branch at Shaw Boulevard, Mandaluyong City, where Elma Capistrano, the branch manager, personally attend them. Upon Elma's instruction, Lita Sagun, the bank teller, prepared BPI cashier check number 14428 in the amount of 348,805.50, drawn against the account of Marisa Kawili, payable to the respondent. Rodrigo then handed the check to the respondent in the presence of Alma. The following day, April 1, 1993, respondent returned the petitioner branch at Shaw Boulevard to encash the cashier's check, but it was dishonored. Elma informed him that Marisa's account was closed on that date.
Despite the respondent's insistence, the bank officers refused to encash the check and tried to retrieve it from him. He then called his lawyer, who advised him to deposit the check in his own account at City Trust, Ortigas Avenue. However, the check was dishonored on the ground account closed. On September 23, 1993, the respondent filed with the Regional Trial Court, Branch 263 at Pasig City, a complaint for sum of money against the petitioner, docketed as Civil Case Number 63663. The respondent prayed that the petitioner be ordered to pay the amount of the check, damages, as well as the cost of the suit. In its answer, the petitioner specifically denied the allegations in the complaint, claiming that it issued the check by mistake in good faith, that its dishonor was due to lack of consideration, and the respondent's remedy was to sue Rodrigo Kawili, who purchased the check. As a counterclaim, petitioner prayed that the respondent be ordered to pay the attorney's fees and expenses of litigation. The petitioner then filed a third-party complaint against the spouses Kawili, where they were later declared in default for their failure to file their answer.
So, the decision. It favored the plaintiff, Gregorio C. Rojas. Orders the defendant, Bank of the Philippine Islands, to pay the following: the sum of 348,805 pesos and 50 centavos, the face value of the cashier's check with legal interest thereon computed from April 1, 1993 until the amount is fully paid. Second, the sum of 50,000 pesos for moral damages. 3. The sum of 50,000 pesos as exemplary damages to serve as an example for the public good. Fourth, the sum of 25,000 pesos for and as attorney's fees. And the fifth, costs of suit. After that, there was a third-party complaint. So the third-party defendants, spouses Rodrigo and Marisa Cuili, are hereby ordered to indemnify defendant Bank of the Philippine Islands such amounts, adjudged and actually paid by it to herein plaintiff Gregorio C. Rojas, including the costs of suit.
BPI presented that Rojas is in due course is an error. As stated at that in Section 52, a holder in due course is a holder who has taken the instrument under the following conditions. As a general rule, under the above provision, every holder is presumed prima facie to be the holder in due course. He has to prove that one or more conditions required to constitute a holder in due course are lacking. In this case, petitioner contends that the element of value is not present. Therefore, respondent could not be a holder in due course. It was also stated that in Section 25, value what constitutes. Value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt continues value and, and is deemed as such whether the instrument is payable on demand or at a future time. Furthermore, it bears emphasis that the disputed check is a cashier's check. In International Corporate Bank v. Spouses Cueco, this court held that a cashier's check is really bank's own check and may be treated as promissory note with the bank as the marker. The check becomes primary obligation of the bank which issued and constitutes a written promise to pay upon the demand. In New Pacific Timber and Supply Company Incorporated, recent years, this court took judicial notice of the well-known accepted practice in the business sector that the cashier's check is deemed as cash. This is because the mere insurance of the cashier's check is considered as acceptance thereof.
So with that being said, the petition is denied. The assailed decision of the Court of Appeals, 4th Division, and CAGR, CV number 67980, is affirmed. Costs against petitioner.
Once again, this video digest is about General Register Number 157833, Bank of the Philippine Islands as the petitioner versus Gregorio C. Rojas. Thank you for listening. Good day.